So, hi everyone. I am Laura, and today I'm going to be talking about two women who formed the basis of my thesis, and that's Elsie Bowerman and Chrystal Macmillan. So Bowerman and Macmillan were among the early cohort of early women barristers. Until the Sex Disqualification Removal Act in 1919, women couldn't be lawyers. Bowerman and Macmillan were called to the bar in 1924, which was only 2 years after the first woman, Ivy Williams. And in their legal careers, Bowerman and Macmillan didn't achieve traditional success, that of being appointed KC or becoming a member of the judiciary. However, as the title of this paper suggests, Bowerman and Macmillan were not only lawyers, they were also activists. Both women's activism roots lay in the women's suffrage campaign. However, this was sort of merely a jumping off point for activism that was broad and lasted their entire lives. And gender always remained a crucial component of that activism. So in their dual roles as lawyer and activist, both women negotiated the construction and development of their identities in a society in which gender inequality was rife in law, in professions, and in everyday life. So here are just two photos of Chrystal and Elsie. Chrystal's looking very fetching in her wig that looks like it did fit really well, and no hat. As Caroline mentioned earlier, there was lots of debate in the press about what was appropriate for women barristers to wear in court. So I'm just going to talk about some key themes that are in this talk and in my thesis. So a central component of this paper is the concept of professional identities and what is meant by this. And there are long-standing sociological theories that argue that professions have very distinguishable attributes, so a monopoly of a particular expert service, a rigorous training process, and self-governance. And as such, the legal profession is kind of a classic example of a profession. Whether or not political activism is a profession is less clear-cut. And placing professions within their proper historical context reveals that there's a clearly gendered aspect of this particular term. Women have traditionally been excluded from entrance into male-dominated, prestigious professions due to social conventions, which can be seen in law, where it took legislation for women to be able to enter. And then in contrast, women-dominated professions have often been difficult to be perceived as professions and as the practitioners as professionals. So whilst the political activism done by Macmillan and Bowerman throughout their lives might not fit into the traditional parameters of a profession, I argue that it was professional in nature. So both women worked within hierarchical organisations in which their specialised knowledge of gender inequalities was not only valued, but also granted them special expertise status. So for example, Macmillan was a long-standing member of the National Union of Women's Suffrage Societies, or the NUWSS, and she spoke at parliamentary committees. She was a key figure in many of the feminist campaigns throughout the early 20th century. So the multiplicities of identity will also be explored in this paper. And I've been influenced in my thesis by James Fearon and his theories on identity, in which he sort of thinks about two linked strands of identity, that of social and personal. So in terms of this paper, the social identity of Bowerman and Macmillan is kind of the public presentation of their identities, the personas that they wanted exhibited to the outside world. So this would of course include membership of the legal profession, being identified as a barrister, and as well as their status as feminist political activists, including their membership of political organisations. In contrast, the personal strand of identity refers more to the subject's self-derived internal formulation of themselves. And it's important to note that these two facets aren't strict, they aren't fixed, they often interlink with one another, and often one sort of goes into the other. So for example, Bowerman's social identity as a feminist pioneer is linked to her personal formulation of herself as a feminist. and in turn her feminist ideology changed and developed throughout her life. So what complicates both women's social identities as legal professionals is that prior to them embarking on their legal careers, they already had very strong and clear conceptions of themselves as activists. So as previously mentioned, both were active in the suffrage campaign. Macmillan was a long-time executive member of the National Union of Women's Suffrage Societies, and you can see in this photo on the left, Millicent Fawcett speaking at one of their events. And Bowerman was devoted to the Pankhurst-led Women's Social and Political Union. And on the photo on the right, you can see Chrystal Pankhurst and her friend Annie Kenny holding up a very famous Votes for Women sign. So their activism didn't end with the advent of partial suffrage in 1918. Bowerman continued her activism. She was strongly opposed to industrial action, and she travelled the country campaigning against it. Macmillan was more focused on the elimination of legal inequalities for women under the law. She specifically focused on the issue of married women's nationality, and also on protective legislation for women workers and differential insurance treatment. So Bowerman and Macmillan didn't merely create these new separate identities for their legal selves, but they instead merged their experience with activism and politics within their role as barristers. For both women, becoming a barrister was a political feminist statement, and their professional identity came about because of their already established political activism. As a member of these early women cohorts of barristers, by their very gender, by the nature of them actually being there and being in court, they were making a statement. So it made sense that both identities would interact in a way that differed from maybe a lot of other barristers. And in a sense, then, they were subverting a sort of well-trod trend, a pattern within the profession. When a lot of male barristers then went on to the House of Commons or the House of Lords, becoming barrister politicians, Macmillan and Bowerman were instead political activists turned barristers. And politics seeped into their work. The case that Bowerman specifically highlights in her unpublished memoir is one where she acted as a prosecutor against Harry Pollitt, who was a prominent British communist in his trial for libel in 1927. And she describes in this memoir Pollitt as an enemy of his country, and she was absolutely ecstatic that the decision went against him. So Bowerman's long-standing activism against communists, pacifists and trade unionists meant that this was a big achievement, not just in her legal identity, but also in her activist identity. So despite being well-established public feminist activist figures by the time they were called to the bar in 1924, Bowerman and Macmillan did not become, as Patrick Polden characterises, shining stars of the legal profession. This may be due to a few reasons. Their age, both were older than the average barrister, their continuing political activism, which continued throughout their careers, their legal careers, and of course their gender. So women were not enthusiastically welcomed into the legal profession. The Western Circuit, which is one of the regional routes that barristers and judges travelled on to try cases in localities away from legal hubs, only admitted women barristers to their rank by a vote of 27 to 20 in 1923. So you can see there that there's not this kind of universal overriding acceptance. It's actually very close. And bar messes, which are social events that often provided crucial professional networking opportunities for barristers, often excluded women. It's noted in a book about the Western Circuit that Macmillan used to make a point of retiring from the mess when the port came around. So she's there as a barrister, but in turn, she also has to conform to these social conventions expected of her as a woman. So on top of these barriers to traditional success within law, both women also closely linked their feminist activist identity with their identity as barristers. As previously mentioned, the case highlighted in Bowerman's memoir was the Harry Pollitt case, in which her legal success closely correlated with her political ideology. And Bowerman also had this habit of making sure whenever she signed off a letter, or there was some kind of document that she knew would be maybe saved in her college archives, for example, to make sure she clearly identified herself as a barrister at law. So similarly, Mr. Marshall Freeman, who is Macmillan's former head of chambers, noted in a tribute written to her after her death that she was, and I can never say this word and I'll probably never be able to say it, an indefatigable worker. No, that was worse than last time. She basically was a tireless worker, never happier than when handling a case for the Poor Persons Department, and untiring in her determination to secure justice if the opposite seems to threaten. Again, this suggests that altruistic motives connected with her political beliefs were a key influence in her law career. However, I think you can also read this from a different perspective. Although it wasn't surprising that she was very selfless in her law career, it may be that Marshall Freeman saw a choice where there wasn't a choice. Early women barristers often struggled to build up a practice that was financially viable. And taking on these Poor Persons Department cases may have been a necessity in order to sustain her practice. And this is reminiscent of Margaret Thornton's critique of the illusory nature of the neutrality of law, where male practitioners saw freeing aid decisions where there were none, simply because they perceived law and by extension the profession as a disinterested force. And this wasn't the perception that often early women barristers experienced. So what is success? So from what I've said and what I've spoke about both of women's careers, it's too easy to conclude that Bowerman and Macmillan were not successful in the negotiation of their professional and political identities. Their continued focus on activism during their time at the bar widened the gulf between them and their fellow barristers, a gulf that was already in place simply because of their gender. However, by concluding this, I believe we divorce early women barristers' careers from the political, social and cultural framework in which they participated. Neither Macmillan or Bowerman were so-called bad barristers. So Macmillan was frequently praised. Sir Ernest Wilde was evidently impressed by her. In one case, he described a speech she made in defence of a prisoner as making bricks without straw. And intriguingly, in another early women barrister's memoir, Enid Rosner, she stated that he didn't take too kindly to female barristers. So the fact that he praised Macmillan is even more extraordinary. It's also important to note that in our perception of early women barristers and whether they were successful or not, is that we are judging them against a male-defined and a predominantly male profession. Men had established this criteria for progression within the profession. They had unfettered access to important networking opportunities such as bar messes, and importantly, they didn't have to be pioneers and break down barriers for other lawyers of their gender. By focusing on firsts and who took silk and when, we actually erase the intentions of some of these women. So Bowerman, for instance, states in her memoir that all this public work led me to feel it would be an advantage to be a qualified lawyer. And in this, she clearly conceptualises her role as a barrister in one that would enable her to further her activism. Becoming qualified gave Bowerman's opinions added weight. It helped to professionalise her activism even further. She could then place notices on speeches that she was giving as being done by a barrister at law, and it just gave her that extra kind of authority to speak on the subjects that she was speaking on. So although fellow barrister Enid Rosner suggests that Bowerman and Macmillan made no headway at all in their careers, I argue that this is a fallacy. Both Bowerman and Macmillan created their legal identities as a way to legitimise their activism. They utilised their legal knowledge in order to further their reformist ambitions, and simultaneously, they agitated for change within the profession, merely by their presence and their continued political activism. Therefore, crucial in their understanding of their professional and legal and political identities was this notion of pioneering and paving a way for future women barristers. And as such, the negotiation of their professional identities as both lawyers and as political activists constantly shifted in order to capitalise on opportunities to advance their feminist agendas.